Starting the recording and letting IT know we can start. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5139 et al. Jihad Barnes, appellant, versus Federal Bureau of Investigation. Mr. Miller for the appellant, Ms. Valdivia for the appellate.
Good morning, counsel. Mr. Miller, please proceed when you're ready.
Thank you. Good morning, Your Honors, and may it please the court. Evan Miller for the appellant, Mr. Barnes. Barnes's FOIA waiver is unenforceable because the government failed to satisfy its burden under Price. Price requires the government to show how the waiver's service to a criminal justice interest outweighs the public policy harms that would result from restricting one's access to information. The government's identified interests in this case are either already protected by FOIA exemptions or are not sufficiently connected to the enforcement of the waiver to satisfy Price. The government's interests also do not outweigh the significant public policy harms that would result from restricting Barnes's access to information that may reveal government misconduct. In any event, even if Barnes's waiver is enforceable, it is limited in scope by its plain language to his underlying criminal case.
Why should this issue be determined by this court, by the District of Columbia Circuit Court? He pled guilty in Virginia, and it seems to me that the validity of his plea agreement would be determined by the Fourth Circuit law, not our law. So why shouldn't we rely on the Lucas case in the Fourth Circuit, which upheld a waiver of FOIA rather than Price?
Well, Your Honor, the validity of Mr. Barnes's waiver is really not an issue in a Price analysis. We wouldn't even be conducting a Price analysis if the plea agreement itself was not validly entered. And the Price majority in this court dispense with the idea that all waivers in a plea agreement are enforceable if the plea agreement itself is valid, because that opens the door for the waivers of rights that are not linked to any sort of prosecutorial interest. And the Price majority.
Well, that's another question. My question really goes to whether the waiver of FOIA is upheld or not upheld depends upon the waiver's validity in the plea agreement. And so my question is, shouldn't the validity of the plea agreement be determined by Fourth Circuit law, not DC Circuit, since he pled guilty in the Fourth Circuit?
Well, Your Honor, I think the validity of Mr. Barnes's waiver, I think, has previously been litigated in another court. But respectfully, the validity of the waiver does not preclude a argument that the validity of the plea agreement does not preclude an argument that the waiver itself is invalid. In Price, the court made very clear that they were not concerned with the validity of the waiver, but whether the waiver itself violates public policy. And by validity, I mean, whether it was knowingly involuntarily entered. So in this case, we wouldn't get to an enforceability argument under Price if the waiver was invalid. It would be, unenforceable for different reasons at that point.
But you're attacking the plea bargain, right? You're saying part of the plea bargain is not enforceable.
We are saying, yes, Your Honor, we're saying a waiver of rights in a plea agreement is unenforceable, but the plea agreement itself, we're not attacking.
Why shouldn't you have to go back to the sentencing court to do that rather than start in DDC?
Well, Your Honor, the FOIA request was made, or the FOIA suit was brought in the DDC against the FBI, and so the summary judgment motion, which the court ruled on the basis of the enforceability of the waiver, is at issue before this court, and so that was the posture for appeal to this court. And
why isn't he collaterally stopped I mean, he litigated the voluntariness, intelligence, et cetera, of the plea bargain in the trial court, as Judge, excuse me, Katsas has just pointed out. And if he had a problem with any other portion of the plea, like the FOIA, why wasn't he obligated to raise that before the sentencing court?
Again, Your Honor, the validity of the plea agreement itself really has no bearing on a price analysis. So there's no collateral estoppel or any sort of foreclosure of his arguments here. Here, we're arguing that the FOIA waiver itself in the plea agreement, albeit validly entered, essentially, violates public policy and should be unenforceable on that grounds as the court, on those grounds as the court set out in Price.
Let me ask you one other question, because you raised it, and that is that everything in the plea agreement, anything waived, has to have some kind of criminal justice purpose to it. Suppose the plea agreement said, and this is a matter of state law, said that upon entering your plea of guilty, you realize you're going to lose your voting rights. Is that invalid because it doesn't have a criminal justice purpose?
Well, Your Honor, I think that waiver that the consequence of being charged and convicted of a felony and then losing your rights is under law, as opposed to you making a decision to sign a plea agreement that waives otherwise granted statutory rights. So that's a little bit of a different hypothetical. Whereas here, there is the government has a considerable amount of leverage when entering into a plea agreement with a criminal defendant. The defendant is obviously concerned about the consequences of being charged with a crime and losing.
That sounds like you're now going back to the question whether the plea was voluntary. Let's say you just got finished telling us it doesn't matter.
Correct, Your Honor. It doesn't matter. I was just explaining the position that the government is in and the leverage they have, which is why the Price court was concerned about doing a public policy, balancing test, essentially weighing the interests that the government is allegedly trying to achieve against the public policy harms that would result from enforcement. And the reason why they were doing that analysis is because of the position that the government is in plea bargaining. And that's a little bit of a different situation where your hypothetical is, losing a right that's taken away from you under a different, under an existing law. So the broader context here, which I think is important, is that Congress already struck the balance between these interests. The government basically relies on a criminal justice interest of protecting confidential sources and then later also national security. But Congress already basically implemented FOIA exemptions that achieve those interests. So by enforcing Mr. Barnes's waiver, the government isn't actually forwarding these interests beyond what is already achieved under FOIA exemptions. And so here we have this public policy harm where Mr. Barnes is trying to get information that may corroborate his suspicions that the FBI targeted him on the basis of his religion. And the significance of that information and the public interest in that information is such that it cannot be outweighed by the government's arguments that they are furthering these interests, because they're really not in any meaningful way. They're not achieving them beyond what they can already achieve under FOIA exemptions that allow them to withhold information that discloses the identity of confidential sources and that implicate national security concerns. So seeing that I've already reached my rebuttal time, unless the court has any additional questions, I will reserve the rest of my time for rebuttal.
Okay, thank you, Mr. Miller. Ms. Valdivia, we'll hear from you now.
Good morning. May it please the court. My name is Diana Valdivia, and I represent the FBI in this matter. This case presents this court with its first opportunity to apply the standard that it adopted in the Price case in 2017. 4 years later, the court now has the opportunity to give the district court some guidance on what is a legitimate criminal justice interest that supports the enforcement of a FOIA waiver in a plea agreement. Here, the government has articulated three legitimate criminal justice interests, each of which would were furthered by the enforcement of the FOIA waiver in this case. Any one of those would be enough for the district court to have enforced the FOIA waiver, and certainly in combination, the three outweigh any speculative public policy harms that Mr. Barnes has pointed to that could possibly be harmed by the enforcement of the waiver. The first of those, the protection of third-party individuals, including confidential informant who could be targeted or harmed by Mr. Barnes, is the ground on which the district court upheld and enforced the FOIA waiver. However, this court is involved in a de novo review when a grant of summary judgment in a FOIA case is in question. And so this court can and should address the other two legitimate criminal justice interests that were raised by the government in this case, namely the protection of national security practices and information.
Are you saying that you need those other two interests?
No, Your Honor, we don't need the other two. However, the government did articulate three. The government believes that all three, alone or in combination, could support and do support enforcement of the FOIA waiver. And because it has been 4 years since this court issued the Price decision in 2017, and the district courts have been grappling with exactly how to apply that, could serve as useful information for the courts to have the insights of the circuit on whether those additionally articulated legitimate criminal justice interests can and should uphold the enforcement of the waiver.
Can I just ask a question about the first one, which is the only one that the district court reached, and
Yes.
the one that you understandably say is enough. In the government summary judgment motion, the government invoked the waiver, obviously, and then cited several exemptions that apply as well. I take it in the event that the waiver wasn't alone enough, then there's some exemptions that explain why documents weren't turned over. But one of the exemptions that wasn't cited was 7D.
Oh, Your Honor, the exemptions that were cited in the government summary judgment motion, those were being argued in connection with the documents that were produced by the FBI in this case. So the FBI asserted attempted to enforce the FOIA waiver as to Mr. Barnes's criminal investigative file. However, they also had documents that they viewed as falling outside of the scope of the waiver and that they did produce. There are 16 pages of documents that were produced. Those are cited in a footnote in the government's brief in this matter. They were summaries of phone calls that Mr. Barnes made in 2014, so after his conviction from the Bureau of Prisons facility. Those were BOP records. There was also an OIG report. Mr. Barnes had attempted to launch an investigation of his investigators through filing a complaint with OIG. So those documents were produced. And so the government in summary judgment was seeking to defend its assertion of FOIA exemptions in connection with those documents. So 7D didn't come into play there because those documents didn't relate to the confidential informant. They related to, I believe the exemptions were privacy related exemptions for the other individuals whose names were mentioned in the phone call records between Mr. Barnes and somebody else that were released. So because those documents fell outside of the scope of the waiver, they were not part of the criminal investigative file that led to Mr. Barnes's plea and conviction.
Is there anything that he would have gotten had he not waived or agreed to the FOIA waiver in his plea? Is there anything?
So, Your Honor, I can't answer that question because when the FBI determined that the waiver applied to the criminal investigative file, the FBI stopped at that point and then did not go forward and process the records. So I can't say. The FBI has not done the analysis to determine whether, but presumably there may be documents in the FBI's criminal investigative file that a particular exemption does not apply to, but that analysis has not been done because the waiver was invoked.
If he has the waiver, then I take it your position is that the FBI doesn't have to do redactions of documents, right?
to the documents that fell within the scope of the waiver. That's correct, Your Honor. But the
Right.
FBI did redact the 16 pages of documents that it produced to Mr. Barnes in this matter because those documents fell outside the scope. It processed those, applied redactions, and produced those documents to Mr. Barnes, which was
Okay.
appropriate. It also conducted a search for another aspect. Mr. Barnes requested not only records about himself, but also records about terrorist allegations or an investigation of terrorism against a mosque on 18th Street. The FBI also conducted, it viewed that as outside the scope of his waiver, since the waiver pertained to his own criminal investigation and prosecution. The FBI conducted a search for records of a terrorism investigation or allegations against that mosque and responded to Mr. Barnes, that aspect of Mr. Barnes's request. So it only invoked the waiver with respect to his criminal investigative file. And that criminal investigative file related to the whole investigation, which started as a terrorism investigation 1 month after being introduced to the confidential informant who was working with the FBI in connection with the counterterrorism investigation. Mr. Barnes, as he admitted in connection with his guilty plea.
So anybody, the only person in the United States who could not get the whatever material, assuming there is any, that is not protected by an exemption, the only person in the United States who can't get that is Mr. Barnes.
The only
Everybody,
individual,
every other citizen or non-citizen for that matter, is entitled to get that, but Mr. Barnes isn't.
every other FOIA requester, anyone who submitted a FOIA request would be entitled to the information that FOIA allows, any information that is not exempt or excluded under FOIA.
Yeah.
Mr. Barnes is the only individual who contracted that right away through his plea agreement. The Price Court analogized this to a library and said, you know, there's a difference between removing books from a library, which is what a FOIA exemption essentially does. It takes it out of the public realm. But
Yeah.
Mr. Barnes would be likened to.
And your main argument as far as the evidence is concerned is that you're protecting a confidential source, right?
So the protection of a confidential informant and other third parties, including that confidential informant's family, who were also targeted by Mr. Barnes in this
But
matter.
according to your factual recital, he already knows the identity of the confidential source.
I have two responses to that question, Your Honor. The first one, which I can say on the public record, is that whether he knows that individual's identity, which is not disputed, that the government has acknowledged that he knows that individual's identity, does not mean that he has that individual's location, the location of that individual's family members, who he has also attempted to target. So there's other information, identifying information about that confidential informant that Mr. Barnes does not have.
All you have
So
to
the
do
fact-
is get on the internet, and there's 1,000 different companies that will locate an individual for you. And if you don't want to pay them, then all you do is you go to the tax records for the state to find the address. So.
And Your Honor, the facts demonstrate that that was what Mr. Barnes was attempting to do, although did not succeed, thankfully, in doing in connection with his criminal case. However, the legitimacy of the government bargaining to keep that information away from Mr. Barnes through a FOIA request is still a legitimate aim. And also, I would also like to point the court to the two ex parte classified declarations that the government has submitted in this matter, which can't be discussed in this forum, but those are associated with docket numbers 18 and 59 in the district court docket. The docket number 18 is from 2017, and docket number 59 is from 2019. And also in response to your question, I would refer the court to those classified submissions. Mr. Miller referenced that Congress is the one that has struck the balance here. And I would just like to respond by saying that Congress struck the balance for individuals of the public who would like to submit a FOIA request who have not bargained that right away, contracted that right away through a plea agreement, unlike Mr. Barnes, who, as the court has pointed out, knowingly and willfully bargained that right away in his plea agreement. I see that my time has expired, so unless there are any other questions, we would ask the court to affirm the district court.
Thank you, Ms. Valdivia. Mr. Miller, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. A couple points I want to address. So during the questions of the government's attorney, one topic came up that other individuals can get this material, but what's an important point here and an important point that the court raised in Price is that the waivers of FOIA are often in the best position to obtain information that may reveal government misconduct because the public at large may not know about the case or be otherwise aware of what's happening. And so the important point here is protecting those individuals' right to request information that could, in this case, corroborate Mr. Barnes' suspicions that the FBI is profiling him on the basis of his religion.
There's no guarantee that there's no way of guaranteeing that number one, that's his purpose. Number two, that if he gets the information, he's going to use it in that manner. He's either entitled to it, the documents, or he's not entitled. And if he is entitled, he can throw them in the trash can and not even look at them. So, and there's no way that once he gets the documents that a court is going to enforce his use of them.
That's correct, Your Honor. But the larger point here is that there is a public interest in obtaining that information. He made that purpose very clear in his complaint. And on the flip side of this, we have to weigh this against the harm that the government is presenting. In this case, the government has not shown that the speculative risk to confidential informants that go beyond the exemption is furthered in any meaningful way by the enforcement of the waiver. And our point about Congress already striking this balance is that this court is instructed by Price to weigh the competing interests. Congress has already determined that the government can withhold a large swath of information that could disclose the identity of a confidential source or implicate national security concerns, and is able to withhold that material. But the FOIA allows people to still request and obtain that information. So seeing my time has expired, I would respectfully urge this court to reverse the lower court decision, or alternatively, as we point out in our brief, interpret the waiver narrowly to limit the scope of that waiver to his felon in possession case and not extending to the terrorism investigation.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-7014, Altagracia Sanchez et al., appellants versus Office of the State Superintendent of Education and District of Columbia. Ms. Flaherty for the appellants, Mr. Tutkin for the appellees.
Morning, counsel. Ms. Flaherty, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. My name is Renee Flaherty for the appellants. This court should reverse the district court's dismissal under Rule 12b-6. The District of Columbia requires daycare providers, who are largely immigrants, largely women, and largely poor, to get college degrees in order to continue caring for children. These regulations impose crushing burdens with no benefits. An education in early childhood sounds like a good label, but in these kinds of cases, courts look beyond the labels. There's a disagreement in case law around the country about how much of a law's educational requirements must be relevant in order for them to be rational. And that disagreement has never been resolved on a motion to dismiss. That's because courts actually look at these training programs to see what they're like on a factual record.
Is there any case striking down the requirement like this on rational basis review?
Yes, Your Honor, we've cited several. In federal courts, there are the Cornwell and Clayton cases, striking down cosmetology licensing. And then in the Fifth and Sixth Circuit, there's the St. Joseph Abbey and Craig Miles cases, striking down funeral director licensing. And those were all cases about educational requirements. And the government ignores those cases entirely. The government's chief case, Hatinga versus United States, isn't about educational requirements. It's about milk marketing orders that controlled prices. And it was decided.
It's a requirement to have a degree in child education in order to care for children. And I take your point about the crushing burden. Sounds like a pretty good policy argument, but I'm not sure it makes the requirement irrational. I'm sure you know you have a pretty steep hill to climb on rational basis review.
Yes, Your Honor. And a degree in early childhood education sounds like a good label, and it sounds like it would be relevant. But what plaintiffs are alleging, two things. First of all, to get an associate's degree, I think no one questions that there are many classes that would be completely irrelevant to caring for children. Think about advanced math classes and English composition classes. But plaintiffs are also alleging that the cases within the classes within the major may not be relevant. And that's because these curriculums vary wildly in their composition. And there's no guarantee that my clients would learn anything relevant to caring for children ages 0 to 3.
As long as it's conceivably reasonable, it passes constitutional muster, right?
So that's Beach Communications, and Beach Communications must be read in context. And that's exactly what the court in Cornwell did. There were two opinions in Cornwell. One was on a motion to dismiss, and the court specifically cited Beach Communications there. And it said that plaintiffs will have a heavy burden on remand, citing Beach Communications. But at the motion to dismiss stage, all of the allegations in the complaint must be taken as true. And Beach Communications says nothing about the pleading stage. In fact, Beach Communications wasn't about a motion to dismiss. So plaintiffs have alleged three plausible claims: substantive due process, equal protection, and non-delegation. First, substantive due process. As I said earlier, there's no guarantee that my clients would learn anything relevant if they got an early childhood degree, because there's no single coherent curriculum. And it's irrational for the district to require daycare providers to obtain a credential that isn't going to teach them anything, especially when it places an insurmountable burden on our plaintiffs and hundreds of other daycare providers like them. Many daycare providers in the district, English isn't their first language. And so having them take college level English classes is frankly going to be impossible for many of them. And it doesn't have any bearing whatsoever on whether they're good at their jobs. Plaintiffs also bring a valid equal protection claim. If the government is going to treat different kinds of childcare providers differently, those differences in treatment have to be related to their job. And finally, plaintiffs state a valid non-delegation claim. OSCE acted with complete untrammeled legislative authority here. The government hasn't been able to point to anything that restrained them, and that makes this a unique case. The clearest sign that OSCE was exercising limitless authority here is the regulations themselves. No agency that had some oversight over it was going to require people to get a college degree to do something that they've been doing for thousands of years, caring for small children. And if the court has no further questions, this court should reverse the district court's dismissal under Rule 12b-6, and I'll reserve the rest of my time for rebuttal.
Thank you, Ms. Flaherty. We'll hear from the district now. Mr. Tutkin.
Thank you, Your Honor, and may it please the court, Adam Tutkin on behalf of the District of Columbia and the Office of the State Superintendent for Education. My friend's presentation this morning reveals what this case is really about. Plaintiffs' claims are policy disputes. They dispute the necessity, cost, and wisdom of these requirements. But those disputes are better directed at the political processes. Disputes of a constitutional dimension, they are not. At bottom, plaintiffs in this case attack sensible requirements enacted with commonplace statutory authority. But that attack fails with a straightforward application of well-settled standards. Indeed, in applying those same standards, this court has regularly affirmed dismissals on the pleadings. This case requires nothing different. I welcome the court's questions, but I'm happy to start with the discussion of the due process claim. So turning to that claim, the basis for OSCE's regulation can be summed up simply: requiring childcare providers to obtain a minimum education in serving early children would lead to better childcare. This is no different than requiring a historian to have a history degree. Moreover, science increasingly shows that this is an impressionable age. An individual's educational journey doesn't begin at the schoolhouse, it begins in the cradle. So it's rational to require those working with this age group to have an understanding of this critical time for development. Yet
Under that theory, nobody should be a parent unless they have a college degree, right?
That's not the theory we're pressing here, Your Honor, because we're not saying that these requirements are necessary. And necessity isn't the test for rational basis. We're just saying that it's rational to require a degree, just like it's rational to ask an accountant to have an accounting degree or historian to have a history degree. And we're specifically talking about here too is not all childcare, but childcare in a specific setting, specifically childcare provided to 3 or more unrelated children on a regular basis.
And at some point, though, the mismatch between what's required for these jobs and the intensiveness of what you're requiring, and you have a lot of leeway, but I mean, at some point, this will become irrational, right? I mean, suppose you required that these folks have a PhD.
Respectfully, Your Honor, I think there is a limit where rationality comes up. But I think for the PhD hypothetical, that would be constitutional as a straightforward application of the standard, because it's reasonably conceivable that a degree in early childhood, no matter
in order to care for half a dozen kids in kindergarten.
Again, the standard is just whether it's reasonably conceivable. That might not be perfectly logical. That might be burdensome or unwise, but Beach Communications and Lee Optical tell us that that is a decision for the legislature or the political processes. So I don't think we'd actually ever see a PhD requirement simply because the democratic processes provide the limiting principle in rational basis cases.
Is there anything in the history behind these statutes? Was there some documented problem of abuse? I mean, what led to these statutes?
Sure, 2 responses here. In the regulatory text, we see OSCE considering new research coming to light, increasingly showing how impressionable of an age this is, and how an education and understanding how children develop at this age, and that their educational process really begins at this age would be helpful. The second point I'd want to make here is that there doesn't have to be a documented problem for this to survive rational basis. We think that the regulatory text here does reveal careful consideration by OSCE. However, the Supreme Court has made clear in rational basis cases that empirical support or a documented problem isn't necessary, for the state to pass a regulation. So plaintiffs here try to push their claims forward by misstating the standard. And they say that the education requirements do nothing to further the state's interest, or that there's no guarantee that they will work. But that's not actually relevant to the operative inquiry. The operative inquiry is whether a rational legislator could have thought that the requirements would further the state's interest. And here, just as it's rational to think that a historian would benefit from a history degree, it's rational that a childcare provider would benefit from a degree in early childhood education. Moreover, Beach Communications and Lee Optical tell us that that legislatures or the state can proceed on generalizations and assumptions. And even if they don't turn out to be true in practice, that's from Gregory v. Ashcroft, there's not a constitutional problem because we're more concerned about what could a rational legislator have thought. And so the fact that the plaintiffs can identify certain degree programs where certain courses are not perfectly relevant to their exact type of childcare isn't fatal on rational basis review.
So just to be clear, the standard, if I know that the standard is steep, obviously, and it's that if it could conceivably be rational for a legislature to think that, but it's also, there's a lot of leeway for a plaintiff at the motion to dismiss stage. So they only have to have a plausible claim, right? So, I mean, it's still a steep climb given the rational basis standard, but it only has to be plausible that a rational legislature couldn't have conceivably thought of the justification, right?
So the standard that this court has articulated for a rational basis cases at the motion to dismiss in Hatinga, Emery, and Dixon is that the plaintiffs have to show that there's no conceivable basis for this regulation. So
but I don't understand that, because the word plausible is just missing there. And under Twombly and Iqbal, they require something, but they still only require a plausible claim at the motion to dismiss stage. I'm not saying that this means that you lose here. I'm not saying that, but I'm just saying in terms of understanding the inquiry, I thought from Twombly and Iqbal that the plaintiffs only have the burden to show a plausible claim at the dismissal stage, not a winning claim.
I think what's helpful to understand to put this together is the Comcast case that we cite in our briefs. And there, Justice Gorsuch's opinion explained that at the motion to dismiss stage, to decide what is necessary to make a claim plausible, we look to what the plaintiffs have to prove at the end of their case. And here the rational basis standard is very high. So in many cases, there just won't be facts that make it any more plausible that their claim will succeed, because we're operating, or what we're really looking at is any reasonable conceivable basis. So these cases don't turn on facts or allegations. And the reason
there's a difference, I think there's got to be a logical difference between saying there's no conceivable what's the standard? Let's see. Any conceivable state of facts, any reasonably conceivable state of facts. To say that there's no reasonably conceivable state of facts is one thing, and to say it's not plausible to think there's no reasonably conceivable state of facts is another thing. The second one, I mean, we're still in a zone that is really favorable to you no matter which one we're talking about. And my point is simply that if you interpose the plausibility layer on top of the standard, by definition, it's a lesser burden for the plaintiff to show than if you didn't have the plausibility standard interposed.
Respectfully, Your Honor, I think the way that Hatinga and Emery and Dixon have articulated the standard has been that that plausibility of facts isn't actually important in rational basis cases, just in light of the ultimate merit standard. And so those courts or those cases at articulation of the standard is currently binding on this panel. I understand that the plaintiffs have their issues with that standard, but at this stage, we would adhere to that standard that they have to show no conceivable basis. And we think that a basis is apparent from the regulations themselves and the regulatory history.
Is there any difference between, we're used to hearing cases attacking regulations under the Administrative Procedures Act. Is there any difference between something that's arbitrary and capricious versus something that's irrational?
Yes, so the arbitrary and capricious standard would be more forgiving to plaintiffs because there you can look at burdens. The FCC versus Prometheus radio case, Justice Kavanaugh has said that to satisfy arbitrary and capricious, the regulation must be reasonable. When on rational basis review, there's no consideration really of reasonableness. Rationality is a different standard. So plaintiffs could have raised many arbitrary and capricious arguments, and indeed, many of their arguments sound like arbitrary and capricious arguments. However, they chose not to do so, and they haven't raised any APA style claim, which, as we show in our brief, is cognizable under DC law.
I have one more question because of the familiarity with the APA, and I probably should ask Ms. Flaherty this, but I'll ask you first, and then I hope she can respond too. When we get a case dealing with the validity of a regulation under federal law, the record is not to be developed in an evidentiary hearing before the district court. We take that case and we review the case, whether it starts in the district court or the Court of Appeals, on the basis of the administrative record alone. And so my question is whether you've made that argument that the review should be, the judicial review should be limited to the regulation, or the record developed in producing the regulation.
Just to make sure I answer your question, are you saying for the equal protection and due process claims, whether the record needs to be developed? or for
whether,
an arbitrary.
whether the court is confined to only the record that was developed in the administrative proceedings leading to the regulation.
No, for rational basis review, the evidence, the legislative record is not relevant. Beach Communications tells us that. And other courts of appeals have held that even
is that for a statute, or is it for whether it's a statute or a regulation? Doesn't matter.
Correct. The Supreme Court has never differentiated the type of.
See, I can understand why you would say that the legislative history or whatever is not relevant to the validity of a statute, because oftentimes in various states there is no legislative history to speak of. You know, they don't transcribe hearings and so on and so forth. But when it comes to a regulation, you know, there are procedures that have to be followed, and notice and comment and evidence developed and everything else. So it's a different animal.
That's correct, Your Honor. But for rational basis cases, the Supreme Court has never differentiated by the type of law. We cite in our case Dandridge versus Williams, and that's where the Supreme Court reviewed, using the same standard as Beach Communications, a Maryland regulation. So the type of lead up to the law isn't relevant, because ultimately we're just looking for any conceivable basis. So the record isn't relevant. I'm happy to answer any more questions, but I see that my time has expired.
Thank you, Mr. Tutkin. Ms. Flaherty, I think you stopped with about 4.5 minutes left.
Yes, Your Honor, thank you. So I have 2 points I'd like to make, one addressing a question from Judge Katsas and one from Judge Randolph. Judge Katsas asked whether there were any documented problems that led to these regulations. And the government hasn't pointed to anything. And in fact, they haven't said why OSCE's old requirements weren't enough. And OSCE's old requirements are actually a great example of something that would be rational and constitutional. They required previously what's called a Child Development Associate credential. And a Child Development Associate credential is something that you can look at and see. It's a set curriculum, you know what it is, and you know that it's relevant to caring for children ages 0 to 3. And so that's an example of something that is completely rational. But OSCE hasn't articulated a reason why that wasn't enough, a reason why a college degree is necessary. And leading into Judge Randolph's question, it's because they didn't have to. It's because they weren't held to account. There was no requirement that they develop a record. In fact, they actually refused to translate these regulations into Spanish so that the people who were affected most by these regulations could even read and understand them. And that's just one illustration of how absolutely arbitrary and unaccountable OSCE was being in promulgating these regulations. And my friend's arguments were chiefly factual. There was a lot of talk about the legal standard, but I think the heart of his argument was about the facts. And at this stage, the allegations in our complaint must be taken as true. And we do have a high burden to meet on remand, but we are more than ready to meet that burden. And if the court has no further questions, I respectfully ask that it reverse the district court's dismissal under Rule 12b-6. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Number 20-1389, Cogentrix Energy Power Management, LLC and District Court petitioners versus Federal Energy Regulatory Commission. Mr. Jones for the petitioners, Mr. Glover for the respondents.
Good morning, counsel. Mr. Jones, please proceed when you're ready.
Good morning, Chief Judge Srinivasan, and may it please the court. Christopher Jones for petitioners Cogentrix and Vistra, the owners of several New England power plants that have been designated as critical to the reliable operation of the power grid in the Northeast United States. I've asked the courtroom deputy to reserve 3 minutes for rebuttal. Petitioners were compelled by law to incur new costs to help keep the lights on in New England. They did so, and they now seek cost recovery. That's all this case is about. But in its orders below, the commission, despite decades of reviewing utility costs after the fact, held that a regulated utility must make a rate filing with FERC before it can even incur costs that might later be charged to customers. In our view, FERC's orders badly misconstrued the filed rate doctrine and the rule against retroactive rate making. And the best evidence of that is FERC's inability to produce a single example of another rate having been designed this way in its 85-year history of setting utility rates. Now, the problems with FERC's application of the filed rate doctrine and rule against retroactive rate making are several, but before I walk through them, I'd like to take just a moment to address the statutory framework because the context of this is important. We respectfully suggest that Congress passed Section 219D4 of the Federal Power Act in 2005 to prevent FERC from doing exactly what it did here, finding some creative way to disallow rate recovery of mandatory costs spent to safeguard the reliability of the grid. Section 219 stems from the 2005 amendments to the Act following the historic Northeast blackout of 2003, which were caused in significant part by the lack of a mandatory and enforceable reliability regime. So Congress erected an entirely new regime and required FERC to issue new standards and made them mandatory and empowered FERC for the first time to issue civil penalties to the tune of $1 million per day per violation. Congress was foisting compliance costs and penalty risk on the industry and thus included a special provision to address cost recovery. Section 219B4 directs FERC to permit the recovery of all prudently incurred costs of complying with the new mandatory standards required by the Act. Now, 219B4 must be read as a special rule in our view because 80 years of Federal Power Act jurisprudence already provide for the utility from customers the costs of its prudently incurred costs of providing public utility service. So in our view, 219B4 must mean something more. Now, FERC says that 219D and the reference there to just and reasonable rates necessarily require the temporal cutoff it created in this case. Now, we explained in our briefs why FERC's textual analysis of Section 219D is wrong and why we think the words just and reasonable must mean the same thing in Sections 205 as it does in 219. But you know, we would urge the court to sort of focus on a simpler notion, which is if FERC's view of the statute is right, 219B4 and the cost recovery directive therein is rendered entirely superfluous and is read out of the statute. Now, even if the court doesn't agree with us on the statute, FERC's application of the filed rate doctrine and rule against retroactive rate making in this case is also clearly wrong. And I'd like to quote briefly from the Niagara Mohawk case that we have cited throughout this proceeding, and we've received no answer to from the commission. There, the commission describes.
Can we just talk about the statute for
Yes,
a
sir.
minute? So there's in 205 and all of the history with similar schemes, there comes this very strong presumption against retroactive rate making, right? You have to file the tariff first, and then you can only recover costs prospectively as outlined in the tariff, right?
Generally, yes, Your Honor.
So doesn't your position has to be that 219 affects an implied repeal of the filed rate doctrine?
The textual construct of 219B4 and its references only to 205A and 205B, I think, Your Honor, would support that conclusion. But
do you agree with that framing?
I do, but I would suggest that even if the court doesn't, we have an independent basis to reverse the commission on its application.
In other words, I understand if you go to D, I understand your argument that the text of D can be read to simply say that 205A and B remain effective. And you say that the filed rate doctrine arises out of 205C and D. And let's assume I agree with that much of your argument, but you still need something else to turn off C and D to affect the implied repeal of C and D. So where do I get that from 219?
Well, I think the mere presence of 219B4, Your Honor, would do that. Insofar as Congress had to speak to this for a reason. In other words, we already knew from Section 205, as I mentioned, that we had the ability to recover costs. Congress.
Okay, so if you go to B4, it's either D or B4. So if you go to B4, your argument has to be that all means all, right? And that includes costs incurred after the filing of a tariff, as well as costs incurred before the filing of a tariff. But there's this strong background rule that all doesn't mean all. It means all costs incurred after the filing of a tariff, which strikes me as sort of a FERC-specific analog of the presumption against statutory retroactivity, where, wholly apart from filed rate doctrine, if you had a statute that said all costs, you would not read that to mean costs incurred before the statute was enacted. So why wouldn't we read all costs in B4 sort of, consistent with the filed rate equivalent of that statutory presumption, all costs incurred after filing the tariff?
Well, again, Your Honor, I don't think that's the rule, that it's costs recovered after the filing of the tariff. And so, in other words, the long history of the commission has been to approve costs after they are incurred. The Columbia Gas case we cited at page 42 of our initial brief is sort of the garden variety retroactive rate making case, where a pipeline tried to go back and change the costs that were charged to customers after those costs had already been settled. And that's not at all what happened here. We had no rate. We had no ability to file a rate. So the retroactive rate making rule does not suggest that costs incurred before a rate filing is tendered are disallowed. That's not what the rule says. And so if you to answer your statutory question, it's entirely reasonable, I think, to read the statute in light of the commission's history of approving costs after they are incurred under the prudent utility manager standard, which we cited throughout our pleadings and our briefs, which the commission has not had an answer to. So
what does the retroactivity mean then for you? Because it fences some things out, and what you're saying is it doesn't fence out everything that predates the filing of the tariff.
That's right, Your Honor. So once we have a tariff and we file and we start recovering, we are going to be barred by the filed rate doctrine, the rule against retroactive rate making, from going back and changing those rates as charged and settled with customers. And that's, again, that's sort of the Columbia Gas example I provided. Once we've settled up with our customers for a past period, we can't then go back over time. The key distinction here is we have no rate. The commission keeps saying that we've charged customers for this service and that we've been compensated for it. Well, that's news to us because we don't have a rate on file. And that is the key distinction here. So all we're talking about here is as we stand up an initial rate and incur costs during the nascent years of this reliability regime, at some point you need to file a rate and seek recovery of them. And that's not at all.
When you say we have no rate, you mean you didn't have a rate that would allow for the recovery of the security costs or the enhancement. You had a rate. You weren't working for nothing.
That's true, Your Honor. And so we have a general market-based rate tariff that permits us to participate in the market and sell power. And so, but that again, the commission here, having endorsed this notion of Schedule 17, says specifically these costs, these reliability costs, should be non-market costs because only we, these special generators, have to pay for them. And FERC, as you know, goes to great lengths to ensure a level playing field on the wholesale market. And so they clearly understand the notion that a special subset of generators that play a higher role in maintaining the reliability of the grid and have additional costs shouldn't be forced to recover those under their market-based rate tariffs where they're competing with everybody else.
Do you represent all of the critical facilities within the New England ISO?
Your Honor, that's a question I don't know the answer to because I think these designations can be fluid. So I actually don't know if there are more designations for units besides the two entities that signed our briefs.
The reason I'm asking is I wonder if the other companies filed, rather quickly years ago, filed for recovery of these security related or efficiency related matters.
Yeah, that I can't answer, Your Honor. And the answer is no. And the primary reason for that is we as independent generators, not vertically integrated utilities, we have no contractual privity with the customer base. We rely entirely on ISO New England to pass through costs to customers. So we, the generating community, speaking here at large, had no unilateral ability to come to the commission and cite Section 219 and say, I'd like my costs, please. That had to be developed through the ISO New England process, which, as the record shows, was a source of the unfortunate delay over these last few years of getting the rate on file. But that we don't think is determinative of the legal outcome.
Sorry, why couldn't you unilaterally file a tariff and say, now that we have this new legal obligation imposed on us, we're going to recover the prudently incurred costs associated with it?
So the vehicle for charging customers in New England has to be through the ISO New England tariff. So even if we filed a rate schedule, we would have no ability to simply stick bills in the mail to New England customers. That would have to flow through the ISO. And so ISO New England went through the stakeholder process, a various committee process that everybody's obliged to follow through participation and signing the membership agreement, which we did in good faith and reliance on the ISO to do that.
But Schedule 17 is clear that at least going forward, the individual generators can make their own Section 205 filings.
And once Schedule 17 is in place, that's true, right? And I think we read that to mean is if you don't like the specific formula that's attached to Schedule 17 and you want to do something else, you're free to do that. But Schedule 17 still provides provides the notice that the commission says is so critical to the customers that these costs.
Could you have supplied that notice by making your own 205 filing right at the beginning? And then at least you would have protected yourself on retroactivity grounds because that would have been notice.
I think the commission will tell you, Your Honor, that the notice would only be effective if that rate schedule were filed. And we have a pretty strong view that the commission probably would have rejected that as lacking any basis in the ISO New England tariff to charge customers an out-of-market cost. Because again, all the market costs, the entire cost, the decision to charge market or out of market is all within the umbrella of the ISO tariff and FERC's regulation of it. So we're quite confident that had we done something like that unilaterally, we would have been kicked out on procedural grounds. Now, if I might spend just a moment on what Schedule 17 does say, which is that it contains only one temporal requirement for cost recovery, and that's that the cost must have been incurred, quote, during the period in which the subject facility was designated as critical. Now, we met that requirement. FERC still says no on the basis that Schedule 17 is somehow ambiguous. But we think FERC frankly gave away the farm in its deficiency letter when this is JA page 132, when it acknowledged to the ISO during the proceeding that based on this language, that was the phrase that it used, Schedule 17 appears to allow retroactive recovery. And then if you look at the Lowell testimony accompanying the ISO's filing at Joint Appendix page 70, it's pretty clear there. The witness testifies that the rate design was intended to cover the, quote, previously paid costs that were incurred. So in our view, FERC manufactured the ambiguity in order to apply the filed rate doctrine, which again, doesn't even really apply here. And if I might just cite the commission's own words from Niagara Mohawk, the filed rate doctrine and rule against retroactive rate making are grounded in the enforcement of the terms and conditions of a filed rate schedule, but there is no such rate schedule here. We think that's directly on point, Your Honor. We've cited that case 3 different times in this proceeding and the commission hasn't answered it. I see I am out of time, so if the court has no other questions, I'll reserve the balance for rebuttal.
Okay, thank you, Mr. Jones. Mr. Glover, we'll hear from the commission now.
Thank you, Chief Judge, and may it please the court. I'm Matthew Glover, and I represent respondent, the Federal Energy Regulatory Commission. This is principally a case about tariff interpretation, but I'd actually like to start by responding to a point that petitioner just made regarding the deficiency letter. They say twice in their reply brief, once at page 1 to 2 and once at page 9, that somehow the deficiency letter conceded that Schedule 17 was not clear. And I have 3 responses to that. The first is that the deficiency letter made clear that it was not the commission's official or final statement on this. It was a statement from staff and the Office of Energy Markets asking for more information and informing the filing party, the New England system operator, that their filing was deficient and couldn't be considered by the commission without more information. So the commission wasn't making any pronouncement on what the statute said. If anything, it was suggesting your filing is unclear to us and we would like more information. The second point would be the commission was clear in both the initial order and the rehearing order, which are what's on review here, that it thought that the tariff was ambiguous. I apologize. I think I said statute a second ago. I'm talking about the tariff, the Schedule 17 filing, and that Schedule 17 is best read as permitting only forward-looking costs.
How do you get that out of the language of Schedule 17? Usually you get prospectivity out of provisions that are silent with regard to temporal scope. This schedule is very explicit as to temporal scope. It says costs are recoverable to the extent incurred during the period when the facility is designated. And the designation here happened a couple of years before the tariff filing.
So, Your Honor, Section 2.2A Romanet 1 says what you said. Section 2.2A Romanet 2 says, and during the cost recovery period that'll be designated in Schedule 17. And then Romanet 3 says that the recovery will be through a Section 205 filing. A Section 205 filing allows you to file a rate that you will charge forward-looking. And so the commission was basically harmonizing, I think is the word we use in the rehearing order, Romanet Section 2.2 Romanet 1, 2, and 3 to provide for only forward-looking costs. And this was actually my second response on the deficiency.
What would Romanet 1 do on that view? I mean, of course they need a 205 filing because the past tariff doesn't account for these newly created obligations.
Your Honor, so my first response would be, no, the commission disagrees with the statement that the past tariff doesn't account for these newly imposed obligations. This goes to our point that they had the opportunity to recover costs in the market. If you step back and think generally, these are generators. Generators typically provide service in the market and receive a market rate. And you're presumed when you're participating in the market that the market rate is covering your costs. And so the commission was presuming when these generators were participating in the market that they were recovering their costs. The New England system operator came forward and said, for certain designated critical facilities, the medium impact, we would like to create a billing mechanism where on transmission rates, which requires our cost-based rates, and it requires recovery by the New England ISO collecting and then passing it back to the parties. We'd like to create this new Schedule 17 that medium impact facilities can use to recover their incremental costs. But the example I think captures this is all facilities have to comply with Section 205 critical facility requirements for the low impact category. And the New England system operator didn't propose some new recovery for the low impact category. It's presumed that transmission facilities that are charging cost-based rates in their cost-based rates will recover their costs to comply with the low impact category, and that generating facilities are currently and will continue even after Schedule 17 to recover those costs for the low impact category through their participation in the market. The system operator here is giving a new mechanism that will allow recovery of these costs separate and apart from market participation for these generators. But it's still.
So is the short answer then that Romanet 1 still does work, even if it of its own force doesn't talk about retroactive recovery, because it adds to the market-based rate for these medium facilities in a way that wouldn't otherwise be in existence?
Yes, in that you must, your recovery must be the period that you were designated a medium facility. Yes. Romanet 1 is saying the only costs we're allowing are these incremental costs during this period you're designated, and you're recovering those through a Section 205 filing. And the Section 205 filing allowing only forward-looking recovery of costs because you need to provide notice. You can't retroactively recover for under compensated rates. So I think that's how we're harmonizing the entire thing. On their theory.
Sorry, I missed that. If Romanet 3 on your theory starts the clock from the moment of the 205 filing and directs it only going forward, then that will necessarily pick up every period in which the facility was designated, because it was designated before the 205 filing was made. You're saying, I guess it's covering a hypothetical of someday down the road they get undesignated?
So if facilities can have their designation changed to low impact from medium impact, other facilities may later be designated medium impact. So it's providing for that. And I think it's helpful to look at JA 135, the system operator who wrote the tariff filing, their response to the commission's question regarding what Section 2.2A Romanet 1 means. At the top of the page, they say Section 2.2A Romanet 1 of the proposed Schedule 17 does not address the recovery of, and they use an acronym, but this just means critical facility costs, the medium impact incremental costs, incurred prior to the requested effective date of March 6, 2020. So the system operator is saying right there that it doesn't think Romanet 1 is talking about any costs incurred prior to March 6th. And that's where we said in the rehearing order, and we said in our brief that the system operator itself was acknowledging the ambiguity.
I mean, they just gave a non-answer, right? They just put it on the individual owners to make the case.
No, Your Honor, I disagree. We asked them whether they think this specific language is providing recovery prior to that, and they said that it doesn't. That provision, it does not address the recovery. So this provision doesn't answer the question. And then
they said if an owner wants to seek recovery for periods before the effective date, the owner must explain why the filed rate doctrine and the presumption against retroactivity don't apply.
Yes, and that's their section to B if the answer to A was yes, but their answer in A was not yes. Their answer in A was that it doesn't address it. And so again, we read that in conjunction with Romanet 3, which sets up or brings in the traditional Section 205 filing requirements that only permit going forward costs.
Suppose section or Schedule 17 did address it and said that the generators are entitled to recover all of their past costs that were incurred as a result of being designated a critical facility. If the schedule did say that, wouldn't that violate the filed rate doctrine?
Yes, absolutely, Judge Randolph. I'd have 2 points on that. The first being, if the schedule said that explicitly, this is, again, you start with our tariff interpretation. Our tariff interpretation would be unreasonable, and you'd vacate, what we did because we unreasonably read the tariff as ambiguous. But the commission, in explaining and responding to petitioners, or actually, it's only 2 of the critical facilities here, but the critical facility owners, the 8 of them that participated at the commission level and a few other entities, in responding to them, the commission did explain that allowing these backward-looking costs would violate the filed rate doctrine and the rule against retroactivity. And so we were interpreting the tariff in light of those background principles.
I'm sorry. Suppose I disagree with your reading of the tariff, but agree with what Judge Randolph just said, which is a retroactive recovery going back to 2014 would violate the filed rate doctrine. Are you saying we can't affirm on the ground that you have alternative rationales? You have a tariff-based rationale and you have a rule against retroactivity rationale? I thought you had both.
We do have both. I guess it's difficult because you'd be saying we were unreasonable in our interpretation of the tariff, but our interpretation complies with the filed rate doctrine and rule against retroactivity.
I thought you said if the tariff were interpreted to reach backward in time, it would violate the filed rate doctrine.
Yes.
To me, it seems like it's an independent statutory rationale.
Yeah, I think you could affirm on that ground as an
Want to
independent
give that up? That's
statutory
fine.
rationale.
but
No,
yeah,
I think you could affirm on that ground. It's a little difficult because I'm understanding you to say that, you know, the tariff is unambiguous and it does allow backwards looking costs. We don't think so, but the tariff was therefore unjust and unreasonable, or it violated the filed rate doctrine if it allowed for those costs. I guess that's sort of a remedy aspect. You'd be allowing us to keep Schedule 17 in the New England system operators tariff to recover forward going costs, because recovering backward going costs violates the filed rate doctrine. The commission, in discussing the filed rate doctrine and rule against retroactivity, was explaining to petitioners and these other critical facilities that participated why it would violate those doctrines to interpret the tariff as they wished.
Can I ask you what the individual entities are supposed to do if the system operator, let's just say the system operator just waits for a long time, and the individual entities want to trigger their ability to recover for costs that are being incurred? Are they stuck, or is there something they could do?
So a couple of points to that, Your Honor. Again, we think Section 219 said we need to propose a rule within 1 year, which we did in the incentives rule, allowing for incentive-based rate treatments, including allowing recovery of these costs. We laid out a rule in 2006. The rehearing orders didn't address these provisions, so everyone knew in 2006, but even 2007, that we would allow for recovery in rates that were sought under that. And in 18 USC 3535C, we made clear that any rates you wanted to recover under that rule would be following the filing procedures of Section 205. Now, when they began incurring these costs, as Petitioners Counsel said, because the mechanism here for recovery, the new mechanism, is a transmission, it's a cost-based mechanism on transmission fees. They couldn't file for that. The New England system operator is the only one that can file for changes to its tariff on that aspect, but they could have done a couple things. If they thought that the market rates they were receiving were not allowing them to recover these critical facility costs, they could have filed a Section 206 proceeding saying the market rates as applied to us are unjust and unreasonable because we are entitled to recover these costs and we are not able to recover them. They didn't do that. There's also provisions in the commission's rules, and they didn't come up in this case, so I think it's like 18 CFR 385.713, but they mimic 5 USC 555E, where you can ask the commission for a declaration for clarity within sort of what's going on in its jurisdictional area. And so in theory, they could have in 2013 said, or 2014, we've just been designated, we're about to start incurring these costs in 2016. We would like to know that we'll be able to recover these costs, even though they're in a special mechanism, even though the New England system operator hasn't filed a special mechanism at this point. The transmission tariff doesn't allow for it. And the commission would have told them, we think you recover these in the market, but if you'd like to recover them through a special mechanism, the system operator could propose one. And if it complies with the requirements of the regulation, we will approve it, which we did here.
So as a general matter, all of the, wholly apart from 219 and the cyber issue, all of the tariffs are filed by the ISO, not by the individual owners?
So the cost-based rate of availability in the open access tariff, like the amendments and adjustments to that, are filed by the system operator. It has the filing rights. And what's happening here is it's added to that tariff, this Schedule 17, which describes the rates and it provides a form. And so what system operators do, and I think in their reply brief, they cited their own filings with the commission. Dynegy, I think, is the either upstream or downstream entity that represents Vistra. And I can't recall the Cogentrix entity, but they file a 205 filing with the commission saying we would like to use Schedule 17 to recover our incremental costs between the low and medium level of our critical facility designation, and here are the types of costs we're seeking to recover.
Yeah, that's what I'm finding sort of puzzling, because the way this seems to work in 219 is really the important Section 205 filing is the follow-on one that's contemplated for the individual owners. The Schedule 17 just feels awfully light. It says there will be future filings in which people can seek to recover for labor, equipment, other costs. Doesn't feel like a formula, doesn't feel like it gives much notice to anyone. Feels like all of the media information is going to come in the later filings, which are coming from the individual owners. So I had thought background rule is the individual owners are doing the filings here.
I know I'm in the red light, but I have a number of points to respond to that. I'll try to keep it brief, though. The first is, yes, Your Honor, you absolutely understand this correctly. But the individual owners are doing the filings that are providing notice, that are describing what they're going to recover. But these are generators here. And generators, again, typically recover their costs through a market-based rate. And the ISO is giving these generators this special cost recovery mechanism that transmission purchases are going to pay under the tariff for transmission services. So people who purchase wholesale power are using the transmission system in the ISO. And so this is giving them a mechanism under the open access transmission tariff, or the OATT. I just call it the tariff, though. To file a Schedule 17 filing with the commission to recover. Otherwise, when you're providing transmission service, you get your costs under the other schedules and under other provisions of the tariff, but the tariff didn't have a transmission provision providing for this specific recovery. And so this goes back to, and I hope I sort of, again, giving a broad market overview, cleared things up a little bit, that generators typically recover their costs through the market-based rates for generation, the clearing price, and that this is a separate opportunity for both generators and transmission facilities that would be designated medium impact to recover these costs. And the Dynegy
but the generators are going through the transmission tariff for this limited purpose.
Yeah, for this specific incremental set of costs.
Okay.
And Judge Katsas, I think you were hitting on the point that the meat of what's going to be recovered and all of that is in the Section 205 filing. And I think it was paragraph 28 of the initial order. The commission pointed out that there was there was an entity that wanted formula-based rate for these recoveries in Schedule 17, and we said your Schedule 17 filing, your later 205, could seek a formula-based rate, or you could specify the costs that you have in this period that you want to recover. So you could use a formula rate, but you can also just use this schedule and identify your costs. And that's how we're recovering them going forward. And that's why we're not letting you recover for, the market participation you had since 2013, where we think you had the opportunity to recover these costs. If you didn't recover them, we're not setting a new rate to allow for recovery of that. And I'm well over time, but if I can make one more point in response to your question, Judge Katsas. I think you used the word, the meat of the proceeding is going to be in the critical facilities 205 filing. And that's absolutely true. And that's where the prudence review will occur. If you look at the cases they cite for prudence review, particularly, I think there's like a Northern California or Transmission Agency of Northern California versus FERC 495 F3rd. It's 663, but it's 672 note 8. And in this case is cited in the blue brief at 29. It describes the prudence standard as, quote, a mechanism by which a complainant can challenge a utilities rate under the just and reasonable standard, semicolon. It is an evidentiary tool designed to facilitate a rate challenge. So when the critical facility owners file their 205 proceedings stating the costs they would like to recover using Schedule 17, the commission will engage in prudence review, and it needs to ensure that those costs are just and reasonable. And a party that would have to pay those costs that might think they aren't prudent can use the prudence standard as an evidentiary standard to challenge that later filing. I think that's the meat you're talking
before
about.
you sit down, one question that keeps recurring to me, and that is there anything unique about ISO New England as opposed to other regions? Forget about Texas, but excuse me. Has this issue, another way of asking the question is, has this issue, the issue that we're dealing with here, come up in other regions of the United States?
So in preparation for the argument, I spoke with commission staff and with people that deal with these filings, and they weren't aware of any other ISO or RTO system operator filing a transmission tariff-based mechanism to recover these costs.
So they're all being recovered by market-based rates throughout the United States.
If you were a generator, they would be recovered by market-based rates. If you were transmission, most transmission tariffs, there are some exceptions if you have a contract and things like that, but most transmission providers or transmission facilities recover their costs through these cost of service rates in the open access tariff. So if you were a transmission provider in ISO New England, and you were designated in 2014, presumably you were recovering those rates through your cost-based rate making with the ISO, that these were just among the costs that you were recovering. There, I would say there is, I don't think it's not unique legally about the New England system operator, but just to fully answer your question, this statute in part was passed because of reliability issues in New England. And I think, again, in talking with staff, the New England system operator has been maybe a leader in really applying the critical facilities rules, and a leader, sort of one of the earlier system operators to engage with these rules and want to assure that the New England storms that led to the statute don't happen again in their system.
Okay, thank you.
Thank you.
Just, sorry, one last question on the statute on 219. What's your response to what I think is the best argument on the other side, which is 219 seems to do oddly very little if it simply means it preserves the filed rate doctrine and the rule against retroactivity, and just confirms what would otherwise be the case, which is that all prudently incurred costs can be recovered. Is the work there what you were talking about in shifting from a market rate to a cost rate? Is that the work it's doing?
As to the B4, yes, absolutely. That would be the work it's doing. 219 itself obviously required the commission to issue a rule, and there's a whole lot of other incentive rates there. 219,
when you look at it writ large, it seems that Congress is very intent on encouraging this kind of investment and making sure that generators are compensated for it. It's a pro-recovery statute, and just seems odd in that context if you read all of this language to just confirm background rules.
So 219 is, I think it's fair to say, it's an incentive recovery statute, but the regulations, the rule we passed pursuant to it has a lot of different incentive rate treatments. This is just one. And we had the San Diego gas case about a different incentive rate treatment. And I know Judge Randolph didn't agree with the commission's position there, but so 219 is, providing, instruction to us to put forward a lot of rules for a lot of different incentive programs. Yes, B4 is permitting us to have this additional cost-based recovery as the system operator is doing here. Otherwise, there wouldn't, that's the statutory mechanism for the system operator to say to the commission, we would like to have this additional, cost-based mechanism to recover these.
I mean, it's requiring you to do that, but I take your point.
It's requiring us to allow the fees. If it were requiring, and this gets to my point about the low impact, if it were requiring us to have a special cost-based mechanism, then all parties would need to be able to recover their low impact fees, but everyone presumes that those fees to comply with low impact are being recovered in the market. It says that we need to allow recovery of prudently incurred costs, but we don't read it as requiring us in the rule to have said, add to all tariffs this specific mechanism. We told the entities that they could file rates with us. And in 3535C, we said those rates needed to comply with 205 and the background rules. And I think I've gone over that. So I know I'm well over time, and I don't want to belabor the point unless you have further questions.
Okay. Thank you, Mr. Glover.
Thank you.
Mr. Jones, will you reserve 3 minutes for rebuttal? We'll give you your 3 minutes.
Thank you, Your Honor. There's a lot there. Let me start with the question about market compensation, if I could. First of all, the low impact is, if all generators in the market are bearing a cost, there's no concern about undue discrimination, and there's no concern about unlevel playing field. And the statute at 219D, which the commission relies on, does in fact require both just and reasonable rates and unduly discriminatory rates. And if we are required to rely on market compensation for costs that only a few generators bear, that is by definition a discriminatory rate regime which would not satisfy the statute. The problem that we have in this case is if, for example, these incremental costs foisted on us are exactly the costs that make us out of the money in the market, they could cause these units not to clear the market. There's nothing in the record that suggests that the commission ever investigated the sufficiency of market outcomes and market compensation for these rates. And that's exactly why the ISO felt compelled to create a separate transmission rate, which council concedes that's what this is. So we have generation rates over here where all the cost of power producing are happening. And we have this critical transmission role that these units play that have to be called out. They are both non-generation costs and they are non-market. So to say that they're just recovered in the market per se, even though the lion's share of generators in the market don't have those costs, again, leads FERC right back into its statutory problem. Now, I'd also like to address the commission staff or staff council referenced the incentives rule and section 3535 of the regulations. Actually, if you read the incentives rule, you will not find a single mention of the rule against retroactive rate making or the filed rate doctrine. So the notion that somehow the reference to filing requirements in section 3535 of the regulations was putting the world on notice that the commission intended to do this is not credible in our view.
Were your clients keeping a separate account for the attributable to the section 219?
Your Honor, we have tracked them. Yes, merchant generators, non-utility generators, by the commission's rules, don't have to follow the uniform system of accounts. So I can't tell you exactly what the accounting was, but absolutely we have tracked the costs that were incremental and caused by.
Well, if you weren't doing that, I'm a little bit confused about how you separate the what you received in the market-based rates as opposed to separating out just the costs that you incurred with respect to the critical facility matter.
Well, I guess I would think about it this way, Your Honor. We certainly don't separate them out in the course of in the day-to-day course. When we make that 205 filing to come into the commission, we can identify the incremental costs that were foisted on us that need to be separated out into that transmission rate. And if I might, on that note, the rates that we filed and commission counsel referenced that we had actually now made these 205 filings, the meat of it, I think it was referred to. And I'll give you the FERC docket numbers so your clerks can pull them. The FERC dockets are ER 21-774 and ER 21-1171. You'll see there is no meat in those filings. And that goes back to how strange this rule actually is. All those filings say is we intend to recover, but it's not until a year from now, as counsel says, well, we're going to do the prudence review. We're going to see the meat. Well, under this rule, we have to file an empty rate. There's nothing in it that says we simply intend to recover. And then a year from now, we get to come back and say, okay, now here are the costs that we recovered for that year. Of course, disallowing the entire 4 to 5 years that we thought we were going to get recovery for. And that then leads me to the question of whether we somehow waited too long. I think the entire notion that we should have done something earlier presupposes that the commission is right. When this was all about the filed rate doctrine, which we think they're not, while this was all going on, we had a good faith assumption and basis to conclude that the ISO, that we could convince them to include past costs in the rate and that was lawful. And so the ISO, as Judge Katsas pointed out, provided just sort of a non-answer. They decided to punt on this to the commission. But in order for you to conclude that we should have somehow come in earlier, presupposes that the commission is right, that there's a filed rate doctrine or retroactive rate making issue here when there's just not. There is no rate on file that we have violated, in contrary to all the commission's precedent on that matter. I'm out of time. Unless the court has anything else, I'll thank the court for its time and urge the court to vacate these orders.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Monday, November 15th at 9:30 a.m.